Hey everybody, it's Christopher Small with CMS Law Firm. We do estate planning, we do probate, we do it well. Today, I want to talk to you about whether or not retitling your house that's owned by you and your spouse into your spouse's name only transfers the ownership of that property to them. All right, now, before we get there, if you have any estate planning questions or probate questions and you would like to talk to me, you can do that for free, in person or over the phone by going to estatemeeting.com. My calendar will pop up. You answer some questions on the date and time you pick. We'll talk. estatemeeting.com. Okay. Today's topic comes from a question from a potential client, which is where most of these come from. This person, I won't really describe the circumstances around why this question was asked, but it was asked nevertheless, and I thought it was interesting. And I think it points out two things. A, sort of the intricacies of community versus separate property in a community property state, and how things that can seem very simple and plain on the surface can be a little bit more complicated underneath. Before we get to this house discussion specifically, let me remind you that Washington State is a community property state. That means basically, don't hold me to this specifically, but basically, generally, any property that is gained, that is acquired after you are married, is owned 50-50 by you and your spouse. The only exceptions to that would be inheritances for the most part. So if you inherit something from your family, whether you're married or not, that is considered to be separate property, so long as it is not commingled, combined with community property. Okay, so in separate property, by the way, is property that you bring into the marriage that you owned beforehand. So if you owned a home before you were married, excuse me, that property would typically remain separate property, your own property to do whatever you wanted with, and would not be a part of a divorce. But that's not what we're talking about that. But separate property, community property, important to remember. Now, typically, when a married couple buys a house, they buy it in both of their names. You know, it says like Jane Smith and Joe Smith. A married couple are buying 123 Main Street, blah, 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 blah. Now, there are times when people want to change the ownership interest in that house to one spouse. Sometimes it's Medicaid planning, sometimes it's some other things, but there are many different reasons for this, I guess. If you are doing this though, and the idea is to relinquish ownership and to essentially give your interest in that house to your spouse, just signing over a deed to them may not be enough. And here's why. Because you own 50% of that asset, just retitling the property in the name of your spouse could be confusing to some and not a direct indication and intention that you are actually intending to give your 50% interest in that property to your spouse. The reason for this is that one spouse can own the property in their name and it can still be community property. So if you want to make sure that the interest in that home is actually given to your spouse, you're going to want to do one of a couple different things. And again, by the way, if you're going to do any of this, do not do this on your own. Do not do this on your own, okay? This is sort of an area that is ripe for mistakes, and you really just want to make sure that your bases are covered, and there may be a way to accomplish what you want without doing what I'm talking about, okay? So just be careful. This is my disclaimer. If you follow this rule, what I'm going to tell you, and it doesn't work, it's not my fault. It's your fault for not calling somebody for help, okay? Now, what I would do is I would do a quitclaim deed, right? Transferring, or at least in name, the ownership interest of the property from one spouse to the other. So if it was Jane Smith and Joe Smith, Joe wants to transfer his interest to Jane, he would do a quitclaim deed to Jane, and now Jane is the only person that is on that property. So when people look it up, they're going to say Jane Smith, owner. Now, that may not be enough to move your community property interest over. So what I would do is I would then execute what's called a post-nuptial agreement with Jane and with Joe, where they both sign acknowledging that the intent is for this property that is now in Jane's name only to become her sole and separate property. Okay? basically what the husband is saying or what Joe is saying is, I'm giving this property to Jane, the whole thing. She can do what she wants with it. If we get divorced, it's hers. Okay. Another thing that I would consider doing is filing potentially, although so we're going to talk about just things that you may want to do to just cover all of your bases. You could also potentially file like a gift tax filing with your income taxes that's showing that you gave that interest to your spouse because it's over $15,000, although you can give as much as you want to your spouse. So you may just do that like for record keeping to just prove like, hey, I'm serious about this. But again, you're going to want to talk to somebody before you do this all the way, because there may be other ways to accomplish your goals other than retitling the property. So the answer is, I don't even remember what the question was, if it was how or what are the consequences or what happens if, but you just heard them all, okay? At the end of the day, the short answer is, if you're going to be doing this stuff with property, with real estate, you want to be careful. There are certain right ways to do it and certain ways that won't accomplish what you want, okay? If you want to make sure you're doing it right, you can call me, talk to me in person or over the phone, estatemeeting.com. If I can't help you out, if I need more expertise, I'll bring it in. I'll tell you what I don't know, what I do know. I can give you some ideas, some answers, and hopefully help you accomplish what you're trying to accomplish, okay? estatemeeting.com. That is it for today. Hopefully you enjoyed this. I'm Christopher Small. I'm the owner of CMS Law Firm. We do estate planning. We do probate. We do it well. If you enjoyed this video, please hit the like button or subscribe or share it or leave a comment if you have a comment. If you liked it, ask a question, whatever you want to do. Thank you for your time, and I'll be here again probably tomorrow to talk to you again.